Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron.
You done messed up, Aaron.
Aaron is here, everyone. Welcome back for more SPTV, where every day is a great day not to be in a cult. Scientology done messed up. Their lawyers done messed up. We're here to talk about it. This has to do with developments in Leah Remini's lawsuit against Scientology. After a bunch of decisions went against Scientology, Scientology filed a peremptory challenge against the judge to get him booted. Because that's what David Miscavige does when he doesn't like when decisions go his way. He goes, let's get rid of this judge. Well, be careful what you ask for, because now Leah Remini is asking for the new judge to be the same judge that is currently presiding over another Scientology related lawsuit from the Bixler versus Scientology and David Miscavige. We're here to talk about the pros and cons of Leah Remini's decision being granted, and we are here to talk about this today with my lawyer friend, Zach. How's it going?
Good, man. Thanks for having me back.
My pleasure. My lawyer friend, Zach, can also be your lawyer friend, Zach, on YouTube. His channel is Your Lawyer Friend, Zach. Okay, we're going to look at the actual document that Leah's team filed with this request. Then we're going to talk a little bit about the document itself. Then we're going to talk about the pros and the cons of whether this request gets approved. So let's take a look at this right here. This action, this is in the action Remini versus Miscavige et al. This action, Remini, is related to the Bixler matter. Guys, Bixler refers to Chrissy Bixler, who is also known as Jane Doe 3. But she publicly does identify herself. So it's okay to know that she's Jane Doe 3. She was Jane Doe 3 in the Danny Masterson case. And Chrissy Bixler and other Jane Does, other of Danny Masterson's victims, some of whom he was charged with, some of whom he wasn't charged with, and some spouses of the victims are suing Scientology for harassment, intimidation, fair game, stalking, conspiracy, all sorts of stuff that they've been subjected to since coming forward publicly in 2016. The judge in that case has made some very unfavorable rulings towards Scientology recently. So that's what Bixler refers to here. This action Remini is related to the Bixler matter in that the majority of the defendants are the same, and because each involves claims of intimidation, stalking, and other tactics that arise out of the defendant's typical operating procedures. To the extent each party is successful, any recovery would be derived from the same sources of these defendants. Furthermore, both cases involve substantially similar questions of law that, but for being related, may result in incongruent rulings. Recent anti-SLAPP motions and rulings have made evident the overlapping issues and possibility of inconsistent rulings. If the cases remain separate and heard by different judges, the cases will require substantial duplication of judicial resources. Moreover, the Remini case is currently unassigned given one of the defendants' Rule 170.6 strike of Judge Hammock. It makes reference there of some recent, possibly inconsistent anti-SLAPP rulings. In the Bixler case, the judge completely threw out all four of the anti-SLAPP motions filed by Scientology. In the Leah Remini case, the judge only threw out a portion of the anti-SLAPP complaints or motions or whatever. I'm sure I'm using the wrong language if you want to, But, okay, what are your thoughts on what we've read so far?
So what we're seeing here is we're seeing an attempt by Leah Remini's attorneys to whatever judge ultimately ends up with this case. And right now, although there's been a peremptory challenge filed, this is it serves to try and do two things. One, get all of where they share a common set of facts, intimidation, stalking, fair game, etc., a common set of defendants, the various entities, and the Keebler King, the chief elf himself, all of those defendants being in common. The judge, in the normal and ordinary course and scope of his or her duty, has to learn all of this information. They have to learn about the organization. They have to learn about the defendants. They have to learn about the law that's at stake here. Judges don't memorize the entire law. They learn what they need for that case, and then they do that on a case-by-case basis. since so much is in common, the lawyers here are arguing, let's get in front of the same judge so they just have to learn at once instead of waiting weeks or months for orders to come down, because the judge is doing an enormous amount of research in the law, trying to figure out how it all fits together in this puzzle. Once they figure it out, they only have to learn it once. You don't have to have multiple judges learning the same thing. They often have clerks, law clerks and research clerks that taxpayers are paying for, and we're asking them to do as taxpayers to do all this writing. And if we can eliminate the amount of resources, that's super helpful. But also, this judge has issued some favorable rulings as it pertains to the anti-SLAPP to the on the Bixler case. And the Remini anti-SLAPP has been resolved, but there's currently no judge. So in theory, if we can tie all of these to one judge, regardless of whether he agrees or disagrees, tie it all to one judge. We only have the judge only has to learn the law one time. And ultimately, as we'll get to it in a minute, whether the judge likes or doesn't like any of the parties or likes or doesn't like any of the witnesses in the long run doesn't matter. But we'll talk about that when we get to that point.
Yeah, I can see the efficiencies that would be created by having the same judge presiding over both cases. In the back of my mind, I can't help but think, be careful what you wish for, because I feel like we've been burned so many times on judges that seemed to be, and I want to use the right words, because I don't want to say on our side or on the right side, because it's not a judge's job to take sides, but where a judge seems to be interpreting the facts in a way where they really they understand that Scientology is up to a bunch of BS. They don't seem to be being persuaded by Scientology's attorneys' BS arguments. I mean, as an observer of these trials, it's easy to get emotional and see the teams and hope that the judge is on one team. And I understand that's not really the way it works, right? But exactly. And we've been burned so many times where it seemed like the judge was leaning in the direction of ruling against Scientology based on everything they were saying up there on the stand and the questions they were asking. And then they come back with a ruling completely in Scientology's favor. And there's a part of me that just goes, well, be careful what you ask for, because you could take out two birds with one judge. Tell me where I might be thinking about this wrong.
So from my perspective, the big issue where a lot of the learning and stuff has to occur, some of the learning will continue to go on throughout the case, but the big issues were these anti-SLAPPs, and they've been decided at this point. Now, part of that is appealable. Leah Remini's counsel asked for the opportunity to appeal that, I believe, or is in the process of making that request if they haven't. Part of that is appealable, part of it's not. And so sorry, I've got a visitor with me today.
That's okay.
I apologize. And so the big learning part has happened, but where it comes in handy is, or where it ultimately doesn't matter, is the judge is a neutral third party in this whole thing. So all the judge has to do is rule on objections when it gets to trial. You could have a witness that isn't liked. You could have, something that maybe would undermine the other case. But the fact is, the jury will ultimately decide these facts. And so essentially what happens is, and the comparison I often make for this is the James and Jennifer Crumbley trial, the parents of the Michigan school shooter. Right. They were tried in front of the same judge to two different juries about 4 weeks apart. But as far as the law, the drafting of the jury instructions and how the law applied to the parents, that didn't change. It was just two different juries. And that's sort of the same thing here. We've got a very similar set of facts that's governed by the same law for the most part. And once the judge gets up to speed on it, it's just faster.
I see what you're saying. Is it your understanding that Leah Remini's lawsuit, having already survived the anti-SLAPP challenge, are there no more barriers in Leah Remini's lawsuit between where we are right now and a jury trial?
Well, there's the entire discovery window, but as far as legal challenges to the substantive part of the case, the meat of the case, there's only one left, and that's called a motion for summary judgment. That is filed in every civil case I've ever had. I've either filed or defended against a motion for summary judgment, and what it says is, this motion for summary judgment says, I'm going to throw this case out because there's no question of material fact. If I send you interrogatories and request to admit your name is Aaron, admit you're out of Scientology, and admit that you live in Clearwater, Florida, and if the issue is, does Aaron live in Clearwater, you say yes, 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 there's no issue left, right? But all you have to say is no to one of those three questions, we go to jury trial. They're going to file the motion for summary judgment to have it kicked anyway. But most of the time, very rarely do motions for summary judgment get sustained. And at least in Oklahoma, I was looking at some new Supreme Court cases the other day, It seems like every time a summary judgment motion gets appealed that was granted, it comes back and say, nope, there's a question for the jury, put it in front of the jury. The litigants have the right to go to a jury. And unless there's just a really great reason not to, they have the right, and we should put them in front of a jury.
Amazing.
But that'll be very late. That's like a very right before trial sort of thing.
Right. So David Miscavige has accepted service in both of these cases, as far as I know. Only Leah Remini has survived the anti-slap. Bixler has survived the anti-slap, except Scientology is still trying to argue the internal arbitration matter in the Bixler case. Scientology chose not to try to argue Leah Remini's case into arbitration, since everything she is suing for happened after she left Scientology. For that reason, even though the Bixler case was filed many years before Leah Remini's case, it does look like Leah Remini's case will be heard first. And I personally was wondering what the risk was of crossing streams, if you will, and somehow bringing evidence before the judge who will preside over the Bixler case, that otherwise he never would have seen, that would somehow in some way prejudice that judge negatively in the Bixler case. And what you're telling me is, who cares if the judge is prejudiced or swayed? He's not the jury.
Exactly. What the judge will do, somebody objects and says, Judge, that's hearsay. Somebody files a motion and says this evidence isn't admissible. That's what the judge is ruling on. Not, did the harassment occur? Did the defamation occur? Did the cover-up occur? Did the conspiracy occur? That's for the jury to decide, not the judge. The judge decides what the jury sees, and that is not governed by the judge's personal opinion. That's governed by the rules of evidence.
Right.
And the judge looks, they look at the rules, and the rules of evidence are simple on their face, but there's mountains, thousands, hundreds of thousands of pages of case law that the judges rely on when interpreting the rules of evidence. So very rarely is there a major evidentiary issue that a judge has never seen before, because we've been using the rules of evidence for 150 years in this country.
Right. Now, in the Bixler case, the judge will still have to rule on the internal arbitration matter, but there's no overlap like Leah Remini's case does. That point's not even being argued. So
correct.
Okay. Super, super interesting. I want to jump back to this form, and I want to look up, I wanted to discuss briefly what this form even is. So it says here, identify in chronological order according to the date of filing all cases related to the case referenced above. So what I asked you briefly before we went live here is, what even is this form? How can someone request a judge? And what's happening here when you're basically going and saying, hey, there's another case that's similar to mine. I'm kind of scrolling all through this form because I thought there was something else that I wanted to see. I guess it probably is just this first line. Identify other related cases. What is this? What is this thing? Why is her team allowed to go, hey, there's another case similar to mine?
For the very simple fact that there's so much interrelated, and that's what this form does. It's normally you've shared a bunch of these on various streams we've done. The orders or the motions that are written by the attorneys is all words. If you look at that form, it's literally a PDF fill in the blank and check the box form. And what you do is you show this case is so closely related and interconnected to this other case that for the ease of judicial resources, for the ease of in the interest of justice, it makes the most sense to put these two cases together in front of one judge to be decided by two different juries at the appropriate time. And in order to determine, are these connected enough, you fill out that template. And that's what that is. It's just a fill in the blank template form.
And in your opinion, what's the likelihood of this request being granted? Is it considered controversial?
It can from time to time, but I think here the cases are so interconnected that it's more of a rubber stamp administrative consideration. Where this is different is one plaintiff is a female, one plaintiff is a male. They don't share any defendants except one defendant together, and it occurred 57 years apart, and 85% of the witnesses that they have in common are dead, for example. They're just not related enough for it to matter. But in this case, I think they're interrelated enough that I think from my perspective, at least in understanding what the intent, what this particular intent of law is supposed to do, I can't imagine where there wouldn't be an issue. Now, where it becomes an issue is, and I believe now the peremptory challenge has been filed by Scientology in both cases, both in the Remini case and in the Bixler case, which in theory, if my math is right on that, the peremptories are gone. So they can't judge shop any longer. Whatever judge ends up with it, if it doesn't stay with the current judge, it gets reassigned. In theory, once that order is adopted, they move together. So if it gets a new judge, they're both moving to that new judge.
It seems like this was a massive misstep by Scientology by filing a peremptory challenge against the judge that was already presiding over Leah Remini's case. Do you see this as neutral or positive as far as Leah Remini's case, Bixler's case?
Oh, I think it's neutral, but keep in mind that there's not a whole lot of logic that comes out of the Big Blue building and the buildings associated with it. So when you talk about it, it doesn't seem like a real logical move. Well, yeah, you're right, but he's not known for his logic. He's known for his spite. So,
yeah. God, I'm trying to think of other issues. Is there any potential downside to this request being granted? I mean, anything at all? Just,
well, I mean, in theory, if you get an adverse evidentiary ruling or something, you would in theory get it in both cases, but the judge will determine the evidence based on the individual facts of each case, not based on what he did yesterday.
right. Okay. I just realized I have to leave. I need to take my daughter somewhere. Sorry, guys. I know there's a bunch of comments here real quick. Vivian Wheeler, welcome, new member. Nana of 12, welcome, new member. Laura Waldy, congrats on your appointment to the SBTV Foundation. Zach, hashtag retire Zach. Fancy Nancy, welcome as a new member. And maybe Fancy Nancy's a member on both channels. Maybe that's what that is. All right, guys, I have to jump. Sorry for the quick exit. Thank you to everyone who watches until the very end. And I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,